Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who tries to make the law make sense on YouTube. Today we're going to look at the opening statement by the defense in the Colorado versus Stauch trial. And I have a few observations to make, and I would welcome your comments. So if you would hang around to the end, I have a question to ask you about the performance of the attorney here. So let's head on down to the beach and talk about this. Now, this case deals with the death of an 11-year-old child. I am not going to go into any of the facts regarding that death, simply because they are too graphic and too gross for my channel. There are a lot of people who watch this channel who don't want to see or hear about graphic violence, and so I don't go into that. And for that reason, I won't be discussing what actually happened to this poor boy on this channel. Rather, I will be addressing my comments to the performance of the defense attorney in his opening statement. I am leaving in place many of the pauses that this attorney uses as he is doing his opening statement. They are usually at least 1 second, sometimes 2, 3, 4, or 5 seconds in between phrases in discrete sentences. I don't know if this is a rhetorical construct that he has developed in order to fill time because he doesn't really have a whole lot to talk about, or whether for whatever reason he just can't seem to marshal his thoughts. Perhaps he has not prepared well for his opening statement. I don't know. But I find the pauses very off-putting. Let's watch.
Mr. Cook?
Now he's going to get up and introduce himself and launch into his opening statement, which should be related to the facts of the case and what he intends to prove.
Jury. I talked to some of you during jury selection over the last couple of weeks. To some of you, I want to reintroduce myself. My name is Will Cook. I, along with Mr. Cellini, represent Letitia Stauch. Now, this is a very tough case. We looked at the jury questionnaires, prosecution. There was a lot of strong feelings. Questionnaires. Have you formed an opinion about Miss Stauch? Had a lot of she's guilty. Had a few she's evil.
People think she's evil? Of course they do.
People forming opinions about this case before they ever hear one shred of evidence. Just a defense attorney in this case is very worrisome. When people have come in and they have preconceived notions of what's going on.
This is argument. I don't know why the prosecution isn't objecting.
With respect to the question on the paperwork that you got about insanity, what do you think about insanity? Is it valid? Something that's legitimate. A lot of people said insanity is just a way to get out of taking responsibility. It's an excuse. So I, as the defense attorney, have two big problems in the case. I represent Ms. Stauch, who, according to a lot of jury questionnaires, is evil and guilty. And us raising insanity is a bunch of BS. A lot to deal with.
Okay, at this point, what he has done is he has laid out the fact that this is a very tough case for the defense. It's pretty obvious that they are not going to challenge in any effective way her guilt. So the only thing that they have left at that point is an insanity defense. An insanity defense means that at the time of the acts for which she is on trial were committed, she lacked the ability to appreciate the difference between good and evil. It is similar to a psychotic break or a fugue state, something where someone just loses all attachment to reason. Now, that's a pretty difficult burden to meet most of the time, but public defenders and defense attorneys always seem to find some psychologist or psychiatrist somewhere who will swear on a stack of Bibles that the person was insane. There is a difference between being insane and just being evil and mean and having a black, cold heart. I can understand going into a fugue state and being irrationally angry at someone, but I can't understand that with regard to an 11-year-old child. In this case, the difference between good and evil is likely to come up quite frequently. The jury is going to be asked to believe that the actions of this woman were, in fact, actions that were motivated by some psychotic break. It'll be up to the jurors to figure out whether that's true or not. Now let's get into the portion of the opening statement where he talks about some of the photographs and the facts of the case and how difficult it is for him as the defense attorney.
Been looking at this case for going on 3 years now. All the photos, I've seen all the reports Mr. Tellini has, and it's a lot. What you saw on the board this afternoon, that's the PG stuff, the rated G information, photos you're going to see. For a general audience, go forward in this case, you're going to see the autopsy photos. And they're horrible. Horrible. It was an awful, awful thing that was done to Gannon. And I see Mr. Allen get up here and he's emotional, almost into tears talking about it. And I get it. I get it. What happened to that little 11-year-old boy is beyond description. The facts of this case.
What he does here is absolutely unforgivable. He says it is a lost cause.
Awful. You know, it's so bad. This is a lost cause. Ladies and gentlemen, I can't quit. I can't leave this courtroom. Got to do my job in this case. Mr. Tellini does. I can't just, after that opening statement, all the information I've seen, the photos, the smiling picture of Gannon, hundreds of witnesses, and 800 pieces of evidence that are going to come in. I can't check out now.
When one of my viewers suggested that I look in on this trial, she claimed that this was probably the worst opening in a case in 2023. Certainly, there is evidence to support that. This is not a good way to start the trial. I have some compassion for my public defender friend here. He has a very rough road ahead of him. His job is to try and save her life, or at the very least, keep her out of prison. For the public defender, in this case, the goal is going to be to try to get her into a mental hospital where Theoretically, if she gets her mental status under control, there might possibly be an option for humanitarian release at some future date. She is going to be incarcerated for a long time. There is no doubt about that, because there is no doubt about the guilt in this case, I don't believe. However, naturally, the jury has the last word on guilt. It certainly is possible that they could blame somebody else for this crime, but I don't see that actually being the case. I think you'll see more of that tomorrow when some of the phone calls between the husband or the ex-husband now and her are released and played for the jury. But at the bottom line, what he has to do is a nearly impossible task of humanizing somebody who, at least from the outside looking in, appears to have committed a particularly heinous crime. It's a difficult job he has, no question about it. But I have a number of issues with this opening statement. Let's start at the beginning, where we look at that first little bit where he is essentially going through the jury questionnaires. This is not an opening statement. This is argument. And the state should have objected, and the judge should have sustained an objection. However, absent an objection, the gentleman gets to do what he wants. And so he engages in argument for several minutes about how ugly the responses to the jury questionnaires are. Now, keep in mind, this is the same person who at some point stood up in front of the jury and said, there are no right answers. You know, when we do voir dire, there's no right answers. You just need to tell me how you feel and be honest, because we're just looking for your honest answers. So they gave him the honest answers in those questionnaires, and he found those answers to be very problematic for his client. The second part of the opening statement, where the young man essentially tries to manufacture sympathy. And let's be clear, it's not sympathy for his client that he's manufacturing here. It's sympathy for him. That's unprofessional. You chose the job that you have as a public defender. Your job is to take whatever comes through the door and do your best job with it. You do not have the luxury of picking your own clients. If you want to do that, then you have to go out into private practice and do that. But what happens here is he talks about how lost the cause is, and he almost walks out of the courtroom. He doesn't quite get to the point where he walks out, but he comes awfully close. Let's watch that again.
You know, it's so bad. This is a lost cause.
Again, that is simply irresponsible and unprofessional, and a good lawyer would not do that. And I think the only reason he does it here is because he doesn't have anything else really to talk about. This is a tragic trial, and I think that it deserves a little bit more attention than the national media has given it. So I will follow some of the parts of this trial, and I will bring them to you. I will do my very best to stay away from graphic images and anything that effectively might cause your stomach to get a little upset, right? But I do think it's important to analyze some of the evidence and some of the witnesses and what they say. So I will be talking about this case. I'll be doing a couple of more videos on it. If you don't like this kind of thing, please don't watch. Don't upset yourself. It isn't worth it. Nothing I have to say is worth me disturbing your peace and sleep and presence of mind. So I would consider it a personal favor, if this kind of thing upsets you, that you not watch these videos. I would like to point out one thing that I think is very good about this particular attorney. And that is, he did not demonize his client. He tried to humanize his client. I think he is trying very hard to be kind to her in spite of the mountain of evidence against her and in spite of the details of the criminal acts for which she is on trial. That is very important, and it's a kindness that only her lawyer can do, because the lawyer on the other side is not going to spare any ammunition painting her as someone who is evil. I will leave the distinction between evil and insane to you. So here is my question for you at the end of the day. Do you believe that we should have a plea of not guilty by reason of insanity? Or do you believe that the plea should be guilty but insane? Because I think that the latter is probably much more accurate and describes things much better. Your thoughts on the insanity defense would be very welcome. Put them in the comments down below, and I'll do my best to get to them. If you have the opportunity today, do something nice for someone, and have a marvelous day. I will catch you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.